welcome to this Red Line webinar on the prosecution of asylum seekers. As you will know if you've read the blurb about this, this has been prompted by the success of Janelle Halil and myself in an appeal against conviction and subsequent acquittal on retrial in a case called Kakai, which we hope has developed a novel defense in the cases of small boats prosecutions. And I'm delighted that we can be joined today by two people who assisted us with expert evidence in those proceedings. Greg O'Kelly from Garden Court Chambers, expert in asylum law, and Francis Timberlake of the Refugee Rights Europe and the Refugees Women's Centre, who gave evidence on the migrant experience. Greg is going to speak in just a moment about the asylum system, and in particular how the criminal justice system intersects and interacts with it. And then Francis is going to address migrant expectations and understandings of the sort of people who make the crossings that the case of Kakai was concerned with. And after that, I hope that we will have a few minutes before the hour mark to answer any questions that are put up in the chat section. So please, as we go along, put up any questions you have and we will try and address them at the end of the talk. And if we can't address them then, I'm sure we will contact those who've asked those questions afterwards. But before we get to Greg and Francis, I'm going to take a few moments to address the case of Kakai, the defense that we developed in that case, and what we hope is the potential impact going forward on small boat prosecutions. We should begin with a little bit of historical context. Small boats cases refer to migrants crossing, usually from the north coast of France, across the British Channel in unsuitable small vessels, usually dinghies or rigid hull inflatable boats. These started to become more frequent in the summer of 2018, and this seems to have been a direct result of some expensive strengthening of the security measures around the significant channel ports, thereby making it more difficult for the historically more usual forms of irregular entry, stowaways on commercial vessels and people hiding on lorries that are passing into the UK. These small boat crossings quickly rose in political salience, and I'm sure most, if not all, are aware of Nigel Farage's attempts to try and politicize these issues. This is despite the fact that small boats crossings have remained a small minority of those arriving irregularly in the UK. But as a result of that political pressure, by the early 2019, the UK government, often in concert with the French authorities, had deployed substantial assets, both policy and maritime, to try and detect and deter these crossings and turn back crossings that had begun. Those interested in the background of these issues can do worse than to consider the, forgive me, I'm just going to bring up our PowerPoint presentation, can do worse than consider the Independent Chief Inspectors of Borders and Immigration's report from December 2019 on irregular arrivals, which discusses the wider policy situation. Part of the policy strategy was to prosecute those who were found to be piloting these small boats. In short, once the small boats were intercepted and interdicted, photographs would be taken of literally the person holding the tiller, and they would be charged with the offence, contrary to Section 25 of the Immigration Act 1971, which I've put up there, facilitating the breaches of immigration law by the other people on board. This, of course, is a section designed to deal with people smugglers and people traffickers. And despite the fact it was widely acknowledged that those on board would rarely, if ever, be the smugglers themselves, who for obvious reasons would have no reason to risk their lives by joining the migrants on board, numerous prosecutions followed in 2019 of those holding the tiller under this section. And as we will see, at least at first, there was no apparent defense. And so these cases were being pleaded to on a regular basis and were routinely attracting sentences of between 2 and 3 years after a plea, which, as we will hear in due course, has some significance for the asylum claims of those convicted. We're aware that a handful, perhaps no more, have contested these cases, but it's always been on the basis of identification, denying they're the person shown holding the tiller in the photograph, or on occasion duress of circumstances. But understandably, given that they've chosen to put themselves in harm's way, those defenses, as far as we're aware, have never succeeded. It's important to appreciate that the Section 25 offence does not afford a defense, either if the person who is charged is a refugee or the person that they have assisted is a refugee. The Article 31 of the Refugee Convention, the so-called Nonpenalization Clause, was only partially enacted into UK law by Section 31 of the 1999 Act. And as a result of that, Section 24, which is one's own illegal entry, Section 25, which is facilitating someone else's illegal entry, and Section 25A, which is assisting asylum seeker for gain, are not covered by that section. And some may consider that a lacuna in the enactment of that international article. Similarly, the fact that there is a specific offence for assisting asylum seekers, the 25A offence, the courts have repeatedly found in the case of Stenaj, case of Bina, and confirmed again if there was any ambiguity in our case of Kakai, that the fact that the persons being assisted as a refugee is no defence and no bar to a prosecution under Section 25. So what was the defence that we developed in the case of Kakai? And first, it's important to understand what an immigration law is for the purposes of Section 25. And it's defined in subsection 2 as a law which regulates entitlement to enter, transit across, or be in a state. And of course, in this context, it's the first of those three subclauses that's of importance, the law regulating entry into a state. The word entry is defined by Section 11 of the same Act. This section, just by way of background, essentially was enacted to deal with transit passengers. And what it says is, normally, if one arrives in the UK, one is deemed to have entered the UK. But when one arrives via a vessel, be it a ship or a plane, you're not deemed to have entered the UK until you disembark. So if you fly through British airspace, you're not deemed to have entered the UK. And even then, if you disembark at a recognized port of entry, let's say Heathrow, you're not deemed to have entered the UK so long as you remain within a designated area. In essence, so long as you remain airside, unless and until you pass through immigration control, at which point you're deemed to have entered the UK. So what's the significance of that section to small boats cases? Well, the case of Kapoor dealt with precisely that situation, the Heathrow situation. Kapoor was dealing with asylum seekers who, through deceit, were able to get on airplanes landing in Heathrow from Thailand. And on arrival, they would present themselves at the immigration desk and claim asylum. And the court held in Kapoor that because they had not yet entered the UK when they claimed asylum, there'd been no breach of an immigration law at that point, and any entry that was thereafter permitted under the regulations to allow their temporary admission for the consideration of their asylum claim was, of course, with leave and therefore lawful. And so there was no offence for those who had assisted them to use deceit to get on these planes under the Section 25 offence. Our argument in Kakai is that the Kapoor situation could be read across to the seaport of Dover. And the court in Canterbury held that that was not a defence in law, but the Court of Appeal held that as a matter of law, the Section 11 defence did apply. But at paragraph 70 of their judgment, the Court of Appeal expressed a significant degree of skepticism whether on the facts of these cases, these small boats cases, anyone could ever realistically expect to get into the relevant part of the Port of Dover, the equivalent of the airside in Heathrow, in order to benefit from the Section 11 defence. The critical point, though, in the case of Kakai was not that he was expecting to sail into the Port of Dover, it was that he was expecting to be taken there. Because as of 2019, the policy for the coastal patrols, British coastal patrols, was that any of these small boats that were interdicted would be either escorted to Dover or would be disembarked at sea and taken to Dover, and a specialist unit within the Port of Dover called the Kent Intake Unit, where they could be processed and where the vast majority, somewhere between 98 and 99%, would immediately claim asylum. All those aboard the two boats that Mr. Kakai had piloted that claimed asylum by way of example. Therefore, those on those boats were in effect being landed in the right part of the port. And so the reality was by 2019, when Mr. Kakai assisted these other migrants, the chief inspector tells us that the coastal patrol crews were complaining that they were effectively being used as a taxi service to deliver migrants from their small boats to the Port of Dover. And so the issue became, the factual issue on the retrial became quite an artificial one, which was, did the migrants on board plan to be rescued at sea, or did they hope to reach the beaches, but expect that it was likely that they would be intercepted at sea? Former, he was not guilty, but if the prosecution could prove the latter, then he was. And what we discovered once the case had been returned to Canterbury Crown Court, that it was remarkably difficult for the prosecution to prove that the intention on board was to head for the beaches. And in fact, in the course of the case, the trial judge, at least on 2 occasions, invited the prosecution to review whether the prosecution remained evidentially sound. And ultimately, he was unanimously acquitted after a couple of hours. The arguments that we were able to deploy to show that the intention was to be rescued at sea, I've set out on this slide. And in very brief summary, the central point is this. The reality is that for the vast majority of people making these crossings, that they expected and wanted to be rescued at sea. If they were not intercepted by the very heavy detection resources that were in place, they were instructed by those who were smuggling them to phone their authorities once they reached British waters. And everything about the crossings supported that. The manner of the crossings, often easily detected in high visibility jackets and life jackets in very slow moving, overburdened, unmaneuverable vessels that had no chances of avoiding interdiction. They would often set off in the early hours of the morning so that they would have the cover of darkness in order to leave French maritime waters, but to ensure that once they reached British waters, it would be dawn and they would have every chance of being rescued. And finally, that the reality was that the people making these crossings positively wanted to claim asylum as soon as possible. There was no point risking their lives to trade living illegally in France for living illegally in the UK. And the safest and most efficient way for them to get in front of an immigration official so they could claim asylum was to do what these coastal patrol crews were complaining of, which was to use the coastal patrols as a taxi, to avoid them staying at sea in these unsafe vessels for any longer than was absolutely necessary. And in that final submission, we were supported by Francis and other NGO caseworkers who were able to confirm that on the ground, the reality is that smugglers would routinely direct the migrants that they were sending off on these trips as to how to calculate when they crossed into British waters and how to call for help if they weren't already intercepted by British coastal patrols. And we were able to rely on case law from drug expert witnesses, which I've quoted on the slide, to use Francis's evidence in that regard. So what are the next steps we hope going forward? Well, the first is the good news that it looks as if many of the pending prosecutions that were awaiting the result of CACI will now be abandoned. In fact, just over a week ago, the CPS abandoned 12 prosecutions, which are the majority of the pending prosecutions that we were aware of. And it has to be hoped that in future, that the lessons from CACI will prevent these prosecutions in future. That said, there are still prosecutions pending that haven't been dropped. And it may be that there is a change of policy. Rather than pursuing under Section 25, that future prosecutions are under Section 25A, the offence of assisting an asylum seeker to arrive in the UK for gain, because that's an offence of assisting arrival. The arrival entry distinction in Section 11 is not relevant, and the issue may well become what for gain means under the 1971 Act, it not being defined in the Act. Often people piloting the boats are doing so in order to be allowed to depart sooner, and it may well be it may have to be litigated in due course whether that amounts to gain for the purposes of this 1971 Act. Secondly, we hope that all those who have represented people in the past, and we believe there are scores of people who've been convicted primarily by their own plea of this offence, will go back and review and consider whether the Section 11 defence may have been applicable in their case. Because if it was applicable, and we suspect that in the majority of these cases it would have been, then it very well may be that there is a strong appeal, even out of time, even following a guilty plea. And we would invite those who are in that position to consider the case of Bowl, which I've quoted here, which says that where someone has pleaded guilty, not being aware that they had a potentially strong defense, that may well be the ground for a successful appeal against conviction. And significantly, there's no requirement that those who represented them originally have been negligent or be criticized in any way. The critical point is that the defence was not made aware to the defendant. They pleaded guilty in error, and in those circumstances, they may well have a good appeal. And so we would urge those who've represented people in the past to consider whether or not they have grounds of appeal following the approach in Bubble. So that was a potted summary of the case of Kakai and where we hope that it will take the law in the future. I'm going to hand over now to Greg, who I know has a lot to say about the asylum system and more particularly its intersection with the criminal justice system.
Thank you very much, Nye. I think I'm really grateful for this opportunity to speak about these issues, especially with such a distinguished panel. What I'm going to do here is try to give an overview of the asylum processes in the UK. I'm not going to be able to do that in a lot of detail. They're hugely, vastly complex, as government after government has tried to make them more difficult to work with, both for lawyers and for asylum seekers. But I'll do what I can, and hopefully the slides will be helpful for people as an aid memoir in future. I'm also going to try to address some of the impacts of criminal convictions and sentences on asylum claims. Both are important, both convictions and sentences. They both have different impacts in different ways. And I'm also going to look briefly at some of the anticipated changes to the system in the UK. It's difficult to do that in detail because of the fact that some of the propositions seem to be trialed in the press and then dropped. And it's hard to say what's actually going to make it into law and what isn't, because we don't have a bill yet. But first of all, asylum in the United Kingdom. Now, if you're a criminal lawyer, you might not be very familiar with the terms of asylum in terms of the practicalities, but Article 14 of the UDHR provides that everyone has a right to seek and enjoy in other countries asylum from persecution. So we have the Universal Declaration of Human Rights, we have the European Convention on Human Rights, but for asylum purposes, what you're always talking about when you talk about the convention, when you talk about refugees and asylum seekers, is the Refugee Convention, the 1951 Convention on the Status of Refugees, and the 1967 Protocol. That sets out who is a refugee. And refugee is someone who meets the definition set out in that paragraph there, which I'm going to break down slightly in the next slide. Because people don't generally understand how narrowly drawn the Refugee Convention is and how difficult it is to actually be granted asylum. But a refugee is somebody who's a fear of return to their home country. That fear is of persecution. So you need treatment reaching the standard of persecution. Prosecution for offences doesn't count as persecution. Somebody being discriminated against doesn't count as persecution. Persecution has to reach a particular level, which is quite a high level before it'll be recognised as sufficient to result in protection under the convention. So your fear of persecution has to be well-founded. So, for example, at the moment, if you're being returned to Mogadishu in Somalia, the fact that Al-Shabaab are blowing people up there all the time doesn't necessarily mean that your fear will be well-founded, because there's a reasonable chance, according to the authorities as they currently stand, that you'll be able to survive without falling victim to those particular risks. So it's, again, quite a high standard. The well-founded fear of persecution needs to be for a specific convention reason, which were the ones I set out in the other slides. So race, religion, political opinion, imputed political opinion. For example, my dad was in the Taliban, so people think I'm in the Taliban, they'll try and kill me for that reason. Or member of a particular social group, which can be quite widely drawn. So, for example, female victims of domestic violence in Pakistan. So the fear of persecution for a specific convention reason then also has to be the specific reason you can't return. And that is essentially the standard you need to meet if you are going to recognize a refugee, and you need to prove it yourself. The burden of proof is on the applicant, and the standard is lower than the ordinary civil standard because it's so difficult to prove. And the standard is reasonable degree of likelihood, although that's something else Priti Patel is looking at. What are the stages of an asylum claim? Now, these aren't the official stages of an asylum claim. These are the stages of an asylum claim I've sort of made up based on having done kind of 10 years of representing asylum seekers. So the first thing that happens is you escape. Otherwise, you don't get to claim asylum in the first place. Often that means you're sent away by your family. So when we're talking about the people who end up being met down the line by Francis or being prosecuted and represented by Nye, you might be talking about somebody who's been sent away by their family, particularly in the context of children, young boys or teenagers. They might not even know why they're being sent. The family will get them out of the country, and they'll generally get them to a family member. So if you're Mohammed in Afghanistan and your uncle Abdul is working in Manchester, they're probably going to send you to Manchester rather than, say, the Netherlands, because there'll be somebody to look after you. You might flee with your family, you might flee alone. You might have already left and circumstances change. So that's your classic example there is your Zimbabwean nurse who's trucking along happily on her Zimbabwean nurse visa, doesn't have to worry about the fact that her family is being persecuted by the MDs, by ZANU-PF if she goes back to Zimbabwe, because she isn't going back to Zimbabwe. But then suddenly there's a problem with her visa and she needs to claim asylum. So yeah, the other classic example is the student. The student is happily working away, doesn't have to worry about his political problems in Bangladesh because he's about to hit 10 years lawful residence in the UK, will get to stay here permanently, but then his college shuts down. He doesn't get that, and then he has to claim asylum. People who are escaping will generally use an agent. So if you have to leave the country, you'll probably go to somebody who's an expert in getting you out of the country, or somebody who knows somebody who can get you out. And one thing that the Home Office don't really take into account, and I suspect the prosecution don't either, is that a lot of people who are fleeing a country don't really have a lot of say in the direction they go or where they go, particularly in the case of young men who are fleeing. They will often be passed from person to person to person. The agent will know where you're going and will have a plan for getting you there. And generally, you'll just be doing what you're told. And particularly in the case of young men, you'll often see examples of pretty severe abuse by agents used to enforce their will. You know, they tell people, don't tell the authorities your real name and your date of birth in Italy or Greece, for example. They'll tell you not to claim asylum, and they can be quite violent if you don't do what you tell them, if you don't do what you're told. Second, travel to your country of destination. You'll often be moving through Europe, typically because the agent will have a particular place in mind. You might be sent somewhere where you speak the language. If your family's gotten to choose where you go to, that'll be a factor that'll go into the mix. They might send you where you have a family member, but again, you may not have chosen the country of destination. And then you actually get to make the asylum claim. Now, there's currently no legal way to claim asylum in the United Kingdom. From if you're in the outside, if you're a Zimbabwean nurse, you can go and claim asylum, but the Home Office will say, well, you should have claimed asylum 7 years ago if you're really at risk, but you can at least do it legally. The policy permitting people to get, for example, get asylum in Italy legally and then seek to transfer legally, they've gotten rid of that policy, so it doesn't exist. You can claim asylum at the airport, but more commonly, if you come in a small boat, you come in at the back of a lorry, you'll claim asylum at a police station. Once you claim asylum, you'll get an appointment to come and register a claim. And if you don't claim at the first opportunity, that will be considered to damage your credibility. I'll deal with that a little bit more later. This sheet looks very complicated. It is complicated. It's designed to set out essentially what the process is. So if you look at the top, you see that's the point where you claim asylum. You undergo a screening interview. Then a decision will be made about whether your claim is being considered in the UK. That can be subject to challenge, but ultimately a decision will be made, and then you'll go into the appeals system. I'm not going to go into this in detail because we don't have the time for it, but this is correct as things currently stand. Section 8, credibility issues. Again, I'm not going to go into this in too much detail, but the Home Office will hold against you in assessing whether it's true that you've been persecuted in, for example, Mogadishu, that you didn't claim asylum immediately, or that you used a false passport. And not only will they hold it against you, but they require by law any tribunal considering a future appeal to also consider that it undermines your credibility that you didn't claim asylum at the first opportunity, which is, in my view, totally unrealistic, because people will claim asylum at the point where they have to. Often you have people who don't want to claim asylum, they want to enter lawfully under a different basis and will only claim asylum as a last resort. That doesn't mean that what they're saying isn't true, but a tribunal is required essentially as a starting point to treat it as being damaging to their credibility. So what happens in a typical claim? So say one of Nye's clients, they come off a boat and then they will claim asylum, for example, having been detained, having met an immigration officer at a police station, a port, wherever. They'll undergo a screening interview, setting out the basics of the claim, then a more detailed asylum interview. The screening interview is important because it will deal with issues like how you came to the UK. And if I was, for example, defending a criminal claim, I think I'd really want to see the screening interview, see what these guys said when they're first interviewed. I'll be very wary of relying too much on it, because essentially the Home Office tends to treat the screening interview as a means of getting out sufficient information to transfer you to a different country. That's or perhaps determine whether you should be detained, or to potentially undermine any trafficking claim you should have in future. That's slightly cynical way of looking at it, but that's my reading of the way they treat these screening interviews. But it is potentially a very useful weapon for the defense, I would think. The asylum interview will be more detailed questioning. Again, if you are defending a claim like this, I'd really want to see the asylum interview. If your claim is refused, you'll get a refusal letter. You can appeal that to the first tier tribunal. And then if that's allowed, you'll get a grant of leave to remain in refugee status. It's important to note that refugee status and a grant of leave to remain, which is an entitlement to be in the country, are distinct things, and you can get one without the other. So, in terms of the impact of conviction and sentence, now, both are important, but they're important in different ways. So, the main ways that those are will affect an asylum claim are, firstly, your credibility is likely to be seen as diminished. So if the Home Office can paint you as a trafficker, essentially, say you arrived here on a small boat with a load of other people claiming asylum who are essentially paying you, and you're only claiming asylum because you've been caught, then that's going to damage your credibility quite severely. You may face deportation, you may face exclusion from the Refugee Convention or from Humanitarian Protection. I'll go into that in a moment, and you're likely to be detained. The Home Office reflexively uses immigration detention, and that's particularly the case in the case of people who've been accused of crimes or indeed have been convicted of crimes. So, deportation versus removal. Deportation is a thing that happens to you if you've committed a crime and the Home Office makes a deportation order as a result of that crime, or because your presence isn't conducive to the public good. And that order invalidates any leave to remain you have, and means that you can't return to the UK while the order is in force, which is usually for a minimum of 10 years. Deportation can follow from criminal conviction under the 1971 Act, by virtue of the 1971 Act. It can follow following an order of the court, to a recommendation for the court. You don't really see them anymore, but you used to see them quite a lot. Court recommend criminal deportation following criminal conviction. And also you get them where there's a it is the view of the Secretary of State that your presence is not conducive to the public good, or where you are deemed to be a foreign criminal because of a criminal sentence over 12 months. Administrative removal is entirely different. Administrative removal is just putting you on a plane and getting you out of the country. There are various mechanisms for doing that legally, but removal is distinct from deportation in that it only happens when you already don't have leave to remain. And it doesn't inherently come with the 10-year ban, although in practice the distinction between the two isn't as clear as it once was. So what's a foreign criminal? A foreign criminal is one of those things that came out in following the Charles Clarke having to resign as Home Secretary in 2006, and the series of dreadful pieces of legislation that followed. So for the purposes of the amended 2002 Act, a foreign criminal is a person who's not a British citizen, convicted of an offence and sentenced to a period of at least 12 months. You notice that 12-month period mirrors the automatic deportation period required. The sentence required to trigger automatic deportation under the 2007 Act. Now, the deportation of a foreign criminal is in the public interest, irrespective of his family connections or how long he's been in the UK for the purposes of Article 8. And if you have been convicted of a sentence of 4 years or more, there's a very high threshold to avoid deportation. Now, the threshold for automatic deportation in Section 32 is also 12 months. So what happens to a foreign criminal? If you're a foreign criminal or anyone else who can't prove their right to be in the UK, upon completion of your sentence, you'll be considered for deportation and you'll generally be detained as well. Detention will in practice be in prison, at least initially, subject to there being sufficient places to transfer somebody under the service level agreement that the Home Office has with the MOJ. Detention can be for a lengthy period, often far in excess of the period of imprisonment. I recently did a case where I had a client sentenced to 15 months imprisonment, and he was detained administratively for 4 years and 6 months, I think, in total before we got him out. In practice, the asylum claim will be considered with a deportation claim, and then the appeal will be heard together. But if you're an immigration lawyer like me doing an asylum claim, and you're having to deal with the fact that your client is also potentially a deportee who's been convicted of a serious crime, then you're already on the back foot. So it's really problematic. So that's deportation. Exclusion. If you were an asylum seeker who's come over on a boat, bringing other people with them, it's obviously a problem if you're facing exclusion from the protection of the Refugee Convention because of the fact that you assisted offenders. So there are two main means by which you could be excluded from the Refugee Convention. Article 1F, which is where you've committed a serious non-political crime outside the country of refuge, and Article 33(2), which provides that you don't have the protection against refoulement. Refoulement is removal to a country where you'll be persecuted. You don't get that protection if you've been convicted by a final judgment of a particularly serious crime and therefore constitute a danger to the community of the country. So Article 1F operates to prevent those who committed serious crimes or war crimes, essentially, from the protection of the Refugee Convention. Article 33.2 deals with people who are already refugees, but then go on to commit serious crime and constitute a danger to the United Kingdom. So in general, at the moment, in the current context, we're probably more likely talking about Article 1F, but it is in principle possible for somebody who is recognized as a refugee here to, go to France, for example, and help a family member to enter the UK. Although I suspect NI's defense wouldn't work then. Anyway, exclusion also applies to humanitarian protection. I've set out the provision there. I don't think we need to go through it in detail. So those are the main problems you have with a criminal sentence or conviction in terms of your future prospects. There's the problem with deportation, the risk of exclusion from protection, and then the damage to your credibility inherent. So I've set out some of the practicalities in terms of exclusion there. It is worth noting that you won't be removed from the UK, even if the exclusion provisions apply, if, for example, you face a risk of treatment contrary to Article 3, so inhuman and degrading treatment. You will, however, be granted restrictive leave, which is really problematic. It means that although they don't remove you, you only get 6 months leave to remain, and will place often very serious limitations on your entitlement to claim benefits or to work. So it's really a strangulation of a grant of leave. So from your point of view, what can you do to help us when we're, as immigration lawyers down the line, dealing with the issues that are going to arise? You need to be aware of the importance of the different lengths of sentence. After 12 months, you get automatic deportation. 24 months, you're going to be excluded from the Refugee Convention. In all probability, the Secretary of State will absolutely try anyway. And after 48 months, any Article 8 appeal will be very difficult to win indeed. Of course, if you just arrived over on a boat, it's going to be difficult anyway. But it's so important to be aware of the potential defences, because if my client can arrive into the first tier tribunal to appeal a refusal of asylum, he's in a much better position than if he's also trying to overturn a deportation order and a deportation decision. There are changes coming. I've just set them out here, sort of. I mean, it's hard to tell what's actually going to happen. You have different reports in different newspapers. Stuff is being suggested and then is being unsuggested. The plans have been described as obscene and unworkable by far left organisations such as the United Nations. But we will see what ultimately happens. For now, the legislation is bad, but we do have the promise of it becoming worse in the future. Thanks very much, guys.
Greg, thank you so much for that. That was fantastic. And you moved through that material so quickly as well. And the use of the emoji at the end is great for the received. Francis, I think you're going to speak now about the migrant experience and the expectations of people making small boat crossings.
Yeah, thanks, Nye. I'm just going to share my screen to get a PowerPoint up. There we go. It should be working. So yeah, thanks for the introduction. My name is Francis Timberlake. I've been working for many years now, long term, with displaced people in northern France, living generally in rough living conditions and informal settlements across the coastline. And in the context of that, I was requested to provide a statement in the case of Mr. Kakai earlier this year. I'm currently working as the UK Research and Policy Coordinator with Refugee Rights Europe, focusing on the policy and legislative response to displacement at the UK border. But previously, for many years, was working as a community support worker with the Refugee Women's Centre, a small organisation supporting displaced women and families in the camps, as well as other vulnerable groups. So that's the experience I'll be speaking to today. Over the years in this work, I've closely observed shifts in the population, as well as the experiences of crossing and of entering the UK asylum procedure for displaced people in the region. And in this talk, I'll try to give you a kind of overall context to the channel crossings from a less legal perspective than Greg and I, and a context to those undertaking them as well. So looking at who are the people crossing from northern France, why are they crossing the channel, and how are they crossing the channel? So to go to the first question, who are the people in northern France whose images have been fairly splattered across our screens, particularly in recent weeks, but also last summer in the context of boat crossings. Many of you will have heard of or have seen images of the so-called Calais jungle, which was demolished in 2016, which was very mediatized at the time. But since then, despite the closure of this camp, there's constantly been a small but significant standing population of displaced people still transiting through the area, mainly around Calais and Dunkirk, attempting to reach the UK. At any one time, to give you an idea of this, there's between 800 and 2,000 people. So the numbers are quite small, smaller than they're made out to be in the media. The majority are younger men, but there's also a large minority of women, families, and young children. So currently there's an estimated 1,800 people living rough between Calais and Dunkirk, displaced people, including 150 women. The majority of these people are from countries of conflict, political or religious repression, economic insecurity, or natural disasters are rife. In Calais, we see predominantly Sudanese, Eritrean and Ethiopian, Afghans and Iranian people. Whilst in Dunkirk, it's predominantly Kurdish people from Iraq and Iran, with a minority as well of Arab Iraqis. So as many of you will know, these countries are amongst the world's highest refugee-producing countries. And they also have amongst the highest, the nationalities have amongst the highest asylum recognition rates in the UK. So as I'll go on to talk about, many of the people that I work with in Northern France will go on to claim asylum in the UK and will also go on to be recognised as refugees, despite the difficult procedures that Greg's just outlined. Most people live in frankly appalling and degrading living conditions, which many of you will have seen images of in the news. These conditions are regularly criticised by both national and international human rights bodies. And to give you an idea of what it looks like, people basically construct informal tented living settlements, either in abandoned warehouses, old industrial sites, or woods around the towns. In almost all of these sites, there's a severe lack of, or indeed no access to water and hygiene, to food, to shelter. And these conditions have been the object of multiple domestic court cases, which have found and ruled inhuman and degrading conditions for those living in them. Needless to say, these are incredibly high-risk living conditions, particularly for vulnerable individuals. The migrant population in the area in general are regularly victims of discrimination and physical violence, both by authorities and by local citizens. They're prey to exploitation by smuggling and trafficking networks, and there's very few protection mechanisms in place. So I think it goes without saying that for people living in these conditions, this creates no incentive to staying in France, and indeed often people's negative experiences of authorities and of living conditions in France are part of the reason why they choose not to stay there and choose to travel to the UK. A report came out recently, actually, which highlighted that 55%, or roughly 55% of asylum in France are unaccommodated, so don't have access to shelter. Which is why many people find themselves in situations like Calais. So this brings us to the next question: why are people crossing the Channel? And the quick answer is people are travelling to seek safety, and they've made a decision that the UK is the place where they will be safest. Evidence provided, which Naid alluded to just now, evidence provided by UK Visas and Immigration earlier in the year found that 98% of people crossing in 2020 by small boat went on to claim asylum. So why the UK? It's a frequent question asked. As outlined above, I think it's important to highlight that the numbers of people that we see in Northern France are actually minimal compared to most people, compared to the numbers that we see elsewhere in Europe, in other European countries where people claim asylum. And so a small fraction of the asylum seekers Europe-wide. It's not the case that everyone wants to come to the UK. But of those who are in Northern France and do hope to come to the UK, the vast majority that I've worked with over the years have either family or close community members in the UK. And if we go back to the countries of origin that I highlighted earlier, these are countries with vast diaspora in the UK, not only due to historical and cultural or historical and colonial links with these countries. Also language, as Greg highlighted, many people have English as a second language or come from countries where English is widely spoken, meaning that people feel there's a higher chance of integration or simply of being able to navigate UK procedures rather than other European countries where they don't speak the language. There's also an understanding, which ranges from more to less accurate, that the UK will be more likely to favourably assess the claim of many of the nationalities that we see in Northern France. as indeed amongst different European countries, there are different asylum recognition rates. So, for example, at the moment, there's a particularly high acceptance rate of refugee recognition rate of Iranians in the UK, and that's one of the nationalities that we see the most at the moment in Calais. So the second part of this question, I guess, is why are we seeing people on small boats? So why are people crossing the channel? In short, as was already spoken to by Nye and Greg, this is basically one of the only ways for people to arrive in the UK at the moment. This is partly due to the fact that for over 30 years, or specifically since 1991, a series of bilateral treaties between the UK and France, and later Belgium, have externalised the UK's domestic border control functions onto French and Belgian soil. These are commonly referred to as the juxtaposed controls agreements. And these allow the UK to wield powers of arrest, detention, refusal of right to enter, and even for UK authorities to carry arms on the French and Belgian coastline, as well as further inland at certain Eurostar stations. The explicit purpose of restricting or reducing immigration. So these agreements basically place the UK border for all operational purposes in France, whilst the treaties at the same time explicitly remove the possibility of placing an asylum claim at the border. Meaning, as Greg highlighted, there is no way to claim asylum across the channel without finding yourself on a boat or on the back of a lorry or another vehicle that will carry you to UK soil. Lorry crossings were the traditional or the most practiced way for people to cross over the last roughly 30 years. But over recent years, heavy securitization and surveillance put in place by the UK government have made lorry crossings particularly dangerous and increasingly difficult. And this has pushed people into new routes that we've seen recently, such as small boat crossings. And boat crossings as a consequence of this harshened border security is actually something that the former Home Secretary Sajid Javid himself attested to in 2018 as we saw a rise in boat crossings. This means that there's now a belief that despite the perils of the channel crossing, boats are generally, for people who take them, an easier and quicker way to reach the UK, since firstly, no official border controls are crossed, and secondly, there's an understanding, as I'll speak about in a second, that people will be intercepted and brought to safety by authorities, which was not always the case, or was more difficult in lorry crossings. So the next question is, how are people crossing the channel? And just to highlight that I'm speaking to my experience in this, and there's of course a wide range of practices that are seen, but this is generally, I think the information that came up is important in the case of Mr. Kakine, which I believe to be important knowledge to highlight. Generally, I'd begin by saying that people are fairly well informed about how crossings, so displaced people are generally well informed about how crossings work and how interceptions work, either by friends who've done the crossings before them, by reading the news simply, or also by agents. However, these are not for the most part highly professional operations by any means. Some groups simply set off, find a boat themselves and cross themselves. Other groups are more heavily reliant on agents to organize the crossing. Whilst on the water, however, people, even who have been reliant on agents, are generally left to cope on their own, since it goes without saying that any semi-intelligent agent or smuggler wouldn't make themselves visible by getting on a boat that is likely to be intercepted by either the French or British authorities. So boat navigation is generally done by the brave or simply unlucky people who find themselves in front of the tiller either because they've had experience of boat crossing in the past, or they've simply got a working GPS on their phone, or, which does happen, they've found themselves in a situation of exploitation and are being asked to work, i.e. drive the boat in exchange for a reduced price of passage. But this is not by any means always the case. And needless to say, when the journeys are long, the driver may change several times during the journey. The large majority of people are intercepted, as we said earlier. This is particularly the case more recently, given that in the past, when boat crossings first became a phenomenon in 2018 to 2019, there were fewer sea patrols in place, whereas now there's been an almost exponential increase in sea patrols, drone cameras and other forms of surveillance, particularly in UK waters, which means that people are incredibly visible. And as a result, there are more interceptions. So why is there an incentive for people who are crossing to be intercepted? First of all, it's seen, as I already said, as one of the quicker and safer ways to present or to go on to present an asylum claim. There's an understanding that once in UK waters, which is quite easy to tell by a GPS, even just a phone GPS, people can call the emergency services, which they generally have the number for help, and will not be returned directly to French waters, even though this is something that Priti Patel is actually pushing to happen. But luckily for the moment, that's not the case. Secondly, for practical reasons, as you'll know, it's a long and treacherous journey across the Channel, despite the fact that it looks short on a map. If you're on a small, totally unprepared boat, it can take hours and hours and be a highly dangerous journey, which means that many people are simply forced to call for help or are aware that it's much better to do so, given that the alternative is risking carrying on for hours unsupported and potentially at risk. Once people are intercepted in UK waters, they're brought to shore and generally taken in charge, although this can mean detention, poor temporary accommodation, including military barracks as of the last year, or long waiting times before they're dispersed elsewhere in the country. But generally, as they arrive on the shore, they'll almost immediately have, the current trend is that they'll almost immediately have their asylum screening interview. So go on to begin the procedure that Greg outlined in his presentation. So I hope that this gives you the basic context to the Channel crossings, to why people are undertaking them, and to the situation that most people who undertake the crossings find themselves in. I'm happy to answer any questions on any elements of it, or provide clarity on some of the information I've included here. But if not, now I'll hand back to you.
Frances, thank you so much. That was very clear and very helpful indeed in terms of giving people a sense of the context of people making these crossings. I don't know whether I'm pleased or disappointed to say there are no questions in the comment section, so we don't need to trouble people further with that. I can confirm that the slides that all three of us have presented, and indeed a recording of this webinar, will be made available through the Red Lion Chamber's website, and I'm sure if Garden Court and Refugee Rights Europe want to do so as well. I'd like to thank both of you so much for not just today, but all the work you did, both at incredibly short notice, both entirely pro bono, to assist us on the case of Kakai, both making a massive difference to the way that the case was perceived by the court and ultimately by the jury. If any of those listening have any further, some questions have appeared. Why do you think that the overall immigration policy of the Home Secretary is so hostile, considering she herself is a foreigner? I will throw that over to Greg, because
she's not a foreigner. She's not. For a start, I mean, like, you can tell in her voice, she's like very Yorkshire. But I mean, it's not really a legal question. The answer, I think, is that it's her brand. You know, she is very popular with the Tory faithful as a result of her tough stance on anything really, and her approach to any law and order question appears to be more and harder really, and that just seems to be that's very popular with the Tory faithful, and that's what got her into the position she's in, and she's probably not going to stop behaving like that now. I mean, she's already gotten away with her bullying allegations and breaking the ministerial code. So I think we're stuck with her for a while.
One of the things that I found particularly appalling working on the case of Kakai was after we secured the acquittal, there were still press releases coming from the Home Office about how many people smugglers they'd successfully prosecuted this year, when the majority of them are people like Mr. Kakai have been prosecuted improperly for this Section 25 offence, when in fact they are migrants who've been exploited. And so it seems unlikely that these prosecutions will stop entirely because the political pressure is there. I don't know if Frances has anything to say on that subject.
Yeah, I was just going to add, I mean, I think we all probably share a feeling of well, being appalled by some of the policies that are coming out, but I would just highlight that although they are particularly kind of preposterous. It's by no means the first Home Secretary who's come out with some of these proposals, such as offshore detention, or two-tier systems, basically selecting refugees or selecting asylum seekers by their means of arrival. Many of these policies were ones that were kind of tested in some form, or at least proposed by the Labour government back in the early 2000s. They heralded many of these policies actually, but they were never workable. And so I think it seems more a trend that each government seems to want to take immigration as or a hard stance on immigration as their flagship set of policies. And it just happens that Priti Patel's has come at a time that seems to coincide, or at least ride off the back of these small boat crossings, and therefore gain much more media attention than usual.
I think I've been doing this job for 15 years now, really, and there has been terrible piece of legislation after terrible piece of legislation. And if you talk to people in the streets, they think that asylum seekers have a really easy ride in the UK, and there's not really a lot you can do about that, because the papers say that. I mean, they don't say that an asylum seeker in the UK lives on £5 a day, or that an asylum seeker isn't allowed to work in the UK unless they have been waiting for over a year for their claim to be considered. And even then, they're only allowed to work as like a nuclear scientist or a ballerina. I mean, there's literally a list, and those are two of the jobs on it. I mean, it's absurd. So, there is Home Secretary after Home Secretary has had to deal with the Daily Mail and Telegraph or whatever, who have strong views on how asylum seekers should be treated. And you often have this, the lives of real people being affected by terrible legislation that is designed to combat a public perception that is going to continue to exist irrespective of the legislation. So I've been an immigration lawyer for 15 odd years, and the only period where we didn't have terrible legislation coming in was 2017 to 2019, when the Tory government didn't have enough votes to get anything through. That was the best time to be an immigration lawyer, where things stopped getting worse for a while, and we were able to kind of like work on the edges of the laws that were there already. But Priti Patel is a step change. I mean, she's directly attacking me and my colleagues in the papers, and she was going on about lefty lawyers stopping justice from happening. Within days of her being aware of one of my instructing solicitors being attacked with a knife in his office by a far right guy who's inspired by her attacks on lefty lawyers. So, things can always get worse, but maybe they'll get better as well. You never know.
Yeah, the next question is, do we think it's likely the CPS will continue to prosecute these kinds of cases even after recently dropping 12 of them? Is it possible there will be political pressure from the Home Office on the CPS to do so? And as I say, they've dropped the majority of cases we're aware of that were pending, but that of course means that there's still a number pending. So plainly the policy is to pursue them where they think there is any possibility of a conviction. The concern throughout the case of Kakai was, despite the repeated enjoinders of the trial judge as to whether or not the case met the evidential sufficiency test under the Code of Crown Prosecutors, the decision kept coming back to trial counsel, who was very reasonable and had a very realistic view of the case, that the case would proceed in any event. And the concern is always that whatever line prosecutors may think, that a strict application of the Code of Crown Prosecutors may not be possible where there is such political pressure to proceed. And the other concern, as I say, is that there may be a strategic move to move across to Section 25A, and we're going to have difficulties with the issue for gain. And when you look at other statutes, such as the fraud statute, theft statute, for gain has always been defined in those statutes as for financial benefit of some sort. So it may well be that we can read across from those definitional sections to the Immigration Act, 1971 Immigration Act, but that's clearly something that's going to have to be litigated in due course if that's the strategic approach that they take. And we watch this space, I think, is the thing to be said. Richard Benyon points out, says that immigration law appears to be a bit of a moving target. I think that's your experience, Greg.
It's nightmarish, yeah. It's there's constantly something new, and I think that's I think it was right. It's very, very complicated. It moves very, very fast. I used to do other areas of work in immigration. I just found I couldn't keep up with anything else that was in any way complicated as well, because it just changes too quickly. So it is like that. I can see it from the point of view of those trying to prosecute. It is very difficult and very complicated, but it is also very political. I mean, like as you're saying now, in respect of the unwillingness to back down. I mean, I have been in the Court of Appeal again in third country cases, cases where somebody's facing removal to another country where they claimed asylum. That my experience is that the Home Office just fights those tooth and nail. I've been in the Court of Appeal with the President of the Family Division telling Secretary of State for the Home Department, you need to go away and take instructions as to whether you should drop this case. And he kind of sheepishly goes out, goes back and goes, no, my instructions are to proceed. And then, he's told, you need to go and take instructions as to whether to drop this case. And he still comes back and, and ends up losing it, because those are the instructions. I find them very, very intransigent, particularly on this issue. I think it's a real political issue that there's a perception that the public will not accept a person claiming asylum if they pass through another country en route. But the reality is that if you are getting your family out of a country where they're at risk, you are going to have chosen a place. You're not going to just go to the first place you come into. That's just not how human beings behave.
Absolutely. I mean, one of the things I found most interesting in working on this case was that the Dublin Convention, something I'd been entirely unaware of, which governed the removal of people who'd claimed asylum or passed through other European countries, has now been rescinded, or we've been withdrawn from as a result of Brexit, which seems to me that one of the most wonderful microcosms of the foot shooting exercise that Brexit has become. Victoria Fudge has said, if the law entitles to claim asylum only once, debarking, do you think this law in fact endangers people's lives who try by any means to get onto the land in order to be eligible to claim asylum? And are there any arrangements made between UK, France, or the EU to take their applications from where they are settled, i.e. Dover, instead for them try to put their lives in danger? I think that's probably a question for Greg.
So if the law entitles you to claim asylum only once, debarking, maybe. I mean, like, the reality is that people are just going to continue to enter and claim asylum. I mean, I think what the law is going to provide is going to be, if the changes come in, is that people will have a kind of a less helpful version of asylum. I think that Priti Patel's idea is that there will be an arrangement between the UK and France. Well, there will be an arrangement between the UK and some other countries as regards transfers and as regards taking settled asylum seekers. But I mean, there are no agreements with any other country. I mean, the Dublin regulation, as it was, worked really well for the UK if you wanted to get rid of asylum seekers, because it said in general you go to the first place that you pass through, and the UK is way up in the northwest of Europe, and Greece isn't, and Italy isn't. So it was really problematic for them. So since that's been gotten rid of, I think it makes things much more difficult for the UK in trying to say to countries like France or Greece, well, I think you should take a bunch of our asylum seekers, because there's no Europe-wide reason for them to have to do that. So I mean, I'm not sure if it'll actually endanger people's lives. I think people will continue to come in the numbers they have, and the numbers aren't very big, really aren't very big compared to, for example, Germany or some other countries, and are pretty steady for the last 15 years as well. Although, again, that's not something you'd see from the press.
Now, I'm told that the 1 hour mark is absolutely sacrosanct, so I'm going to have to draw this to an end. Thank you all for attending. Thank you both for all of your very interesting comments. May I invite any who are attending to consider making a contribution, first of all, to Francis's organisation, the Refugee Women's Centre, and also Care for Calais. Both organisations do absolutely vital work supporting migrants on the north coast of France, and both have given invaluable support to me and Janelle in the preparation of Mr. Kakai's case. I am required to say that the benediction that you have been watching a Red Line Chambers webinar. Please check out the website or social media for other webinars that are upcoming, and please tell your friends. Thank you all very much. And if you have any further questions, I'm sure me, Greg, and Francis will be happy to address them if you want to send them directly through our respective organizations. Thank you all very much.
Thanks, folks.
Thanks very much. Bye.